Welcome back to SCOTUS Oral Arguments and Opinions. Thanks for joining me after last week's flurry of opinions. In today's episode, I'll share insights from last week's opinions, discuss where the court stands this term, and then discuss a major case the Supreme Court just agreed to hear involving prisoner rights and religious liberty. Let's begin with last week's 11 opinions. 4 justices dominated the opinion writing across these 11 cases. Justice Thomas, Justice Sotomayor, Justice Gorsuch, and Justice Barrett each authored exactly 4 opinions spanning majority, concurring, and dissenting opinions. In 7 out of 11 cases, a stable coalition of 7 justices held together. Typically, Chief Justice Roberts, Justice Thomas, Justice Alito, Justice Sotomayor, Justice Kagan, Justice Kavanaugh, Justice Barrett, and Justice Jackson. The 2 justices most likely to break from this emerging consensus pattern were Justice Gorsuch, who dissented in 2 cases, and occasionally Justice Barrett or one of the liberal justices. After joining only majority opinions across 41 decided cases this term, Chief Justice Roberts finally joined the dissenters club. This was the case EPA v. Calumet Shreveport Refining. At the same time, he authored 3 majority opinions last week, matching his entire output for the rest of the term. The most striking pattern isn't liberal versus conservative divisions, but methodological disagreements cutting across traditional ideological lines. In case after case, from EPA versus Calumet to FDA versus Reynolds, justices split based on whether they preferred simple textual approaches versus complex multi-factor tests, regardless of the political implications of their choices. When considering the substance of the opinions, I gleaned a few observations that I wanted to share. Everyone spoke a lot about Schermetti. Rightfully so. However, I wanted to nerd out a little bit and focus on 3 other cases from last week. Esteras v. United States, which saw a rare Thomas-Alito split and the intersection of FDA versus Reynolds and Diamond Alternative Energy versus EPA. Let's start with Esteras. I explained the case on Friday, but on a re-listen, I thought the background was a little unclear. Let me re-explain in the simplest terms possible. Federal judges have a list of 10 areas they can consider when deciding how to punish someone who committed a crime. Think of it like a menu with 10 different options. One of those reasons is retribution. Basically, this person did something bad and deserves to be punished for it. Now, sometimes after someone gets out of prison, they have to check in with a probation officer and follow special rules. This is called supervised release. If they break those rules, a judge can send them back to prison. Here's where it gets interesting. When Congress wrote the law about supervised release, Congress gave judges a shorter menu. Only 8 of the original 10 areas. Congress specifically left out retribution. The big question in this case was simple. Does this mean judges are completely forbidden from using retribution when deciding supervised release cases? Or can judges still consider retribution even though Congress didn't put it on the shorter list? The defendant, Edgardo Esteras, argued judges can't use retribution at all. Congress left it off the list on purpose. The government argued judges can still consider retribution if they want to, even though it's not required. The Supreme Court had to decide, when Congress gives you a shorter list, does that mean you can only use what's on the shorter list, or can you still use everything from the original longer list? Justice Barrett's majority opinion answered in the negative. Judges cannot consider everything from the original longer list. They can only consider what's on the shorter list, meaning that justices cannot consider retribution. The majority built their entire case around statutory interpretation. Justice Barrett's opinion focused on a legal principle called expressio unius est exclusio alterius. When Congress lists specific items, courts presume Congress meant to exclude unlisted items. Highlighting comments from Justice Sotomayor and others in oral arguments, Barrett wrote that Congress was surgical in removing retribution from supervised release decisions. The majority found it significant that Congress removed exactly 2 factors from a list of 10 sentencing considerations. The majority also emphasized that Congress included retribution factors in every other type of sentencing, but deliberately omitted retribution from supervised release. This pattern convinced the majority that Congress intended to exclude retribution entirely. Barrett's opinion was notably confident in its textual analysis. The majority wrote that what Congress said here gets its point across just fine. Justice Alito's dissent, joined by Justice Gorsuch, launched a full-scale attack on the majority's approach. Alito opened with a pointed critique. Veteran trial judges often complain that their appellate colleagues live in a world of airy abstractions. The dissent argued the majority created impossible requirements for trial judges. Alito wrote that judges would need to engage in mind-bending exercises, considering the nature and circumstances of the offense while being forbidden to consider the seriousness of the offense. Alito provided a detailed hypothetical showing how this would work in practice. A judge considering a domestic violence case would need to think, I am inclined to send the defendant back to prison for X months, but was I somehow influenced by moral disapproval and the feeling that part of the additional months is simply what the defendant deserves? The dissent called this a soul-searching obligation that was utterly impractical to enforce through litigation. More specifically, Justice Alito lambasted the majority's use of the expressio unius canon, arguing the majority misapplied this interpretive tool and ignored several viable alternatives. The dissent cited cases like NLRB versus SW General and Barnhart versus Peabody Coal to argue that the canon applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded, and does not apply to every statutory listing. Alito contended the majority failed to consider that Congress might have intended the listed factors as mandatory minimums while preserving judicial discretion to consider additional factors, essentially creating a floor, not a ceiling. The dissent also pointed to the broader statutory structure, noting that other provisions in the Sentencing Reform Act contain explicit prohibitory language, like only these factors or excluding retribution, that Section 3583EL conspicuously lacks, suggesting Congress knew how to write clear prohibitions when it wanted to. Additionally, the dissent argued the majority ignored the possibility that Congress omitted Section 3553 a 2A for more nuanced reasons, perhaps to encourage greater weight on rehabilitation, deterrence, and incapacitation, while still allowing context-dependent consideration of retribution's three components: seriousness of offense, promote respect for law, and just punishment, depending on the specific supervised release proceeding at issue. The majority didn't take the dissent's attacks quietly. Barrett's opinion included several sharp responses to Alito's concerns. When the dissent argued that retributive concepts intertwine with other sentencing factors, the majority responded that courts routinely require judges and juries to attend to some considerations while ignoring others. The majority also included a particularly pointed footnote attacking the dissent's consistency. Barrett wrote that the dissent first complains the majority doesn't consider practical effects, then complains the majority is overly sensitive to consequences when explaining appellate review standards. The majority concluded, there is nothing remarkable about our explanation which simply articulates orthodox principles. Even though the majority won 7-2, the coalition splintered on implementation details. Justice Sotomayor and Justice Jackson declined to join one section of Barrett's majority opinion. Both justices wanted an even broader rule excluding retribution from supervised release proceedings. The majority said courts cannot consider retribution for the original criminal offense. But Sotomayor and Jackson wanted to exclude all retribution, including retribution for violating supervised release conditions. Sotomayor wrote a separate concurrence arguing the majority's approach relied on unnecessary speculation about congressional intent. Jackson wrote that the majority created a practically impossible binary objective for judges. I found this result fascinating for a number of reasons. I thought the majority and the dissent made equally compelling points. I'm a little surprised the dissent didn't peel off another justice or two. What made the battle particularly intense was what both sides couldn't adequately explain. The majority never provided a compelling reason why Congress would create such a complex distinction between different types of retribution. The dissent never explained why Congress would engage in such precise statutory drafting if Congress intended broad judicial discretion. Both sides seem to recognize these weaknesses, which may explain the unusually sharp tone in their written exchanges. Those are a few additional nuggets I found interesting about Hysteris. What stood out to you? Feel free to email and share your thoughts. Now let's turn to the intersection of FDA versus Reynolds and Diamond Alternative Energy versus EPA. Let me refresh on the background of these cases. In Reynolds, R.J. Reynolds Vapor Company challenged the FDA's denial of its e-cigarette marketing applications. However, instead of suing alone in the D.C. Circuit or Fourth Circuit where it was based, Reynolds teamed up with tobacco retailers in Texas and Mississippi to file in the Fifth Circuit. The FDA argued that only disappointed applicants, not retailers, could seek judicial review under the Tobacco Control Act. The Supreme Court disagreed, holding 7-2 that retailers who would sell the tobacco products if not for FDA's denial are adversely affected and can seek judicial review. Diamond Energy versus EPA involve fuel producers challenging EPA's approval of California regulations that require automakers to manufacture more electric vehicles and fewer gasoline-powered vehicles. The fuel producers argued these regulations reduced demand for gasoline and other liquid fuels, causing them monetary injury. The D.C. Circuit held they lacked standing because they couldn't show that invalidating the regulations would actually cause automakers to produce more gas-powered cars. The Supreme Court reversed 7-2, finding that fuel producers have standing because invalidating the regulations would likely lead to more gasoline sales through predictable market effects. Both cases present the Supreme Court with a fundamental question that keeps recurring in our regulatory state. When the government regulates one party, can other affected businesses challenge that regulation in federal court? This is particularly complex when the challengers aren't directly regulated, but claim to suffer economic harm through market effects. In both cases, the government agencies and their allies argued that the challengers needed to produce extensive evidence about how third parties, retailers and Reynolds, automakers and Diamond Energy, would actually behave if the regulations were invalidated. The Supreme Court had to decide whether standing doctrine requires this kind of detailed proof, or whether more general economic reasoning suffices to establish that judicial relief would redress the claimed injuries. Looking at two major standing decisions from June 20th, let me start with what these cases were actually about. In FDA v. Reynolds, R.J. Reynolds Vapor Company wanted to challenge the FDA's denial of its e-cigarette marketing applications, but instead of suing alone in the D.C. Circuit or Fourth Circuit where it was based, Reynolds teamed up with tobacco retailers in Texas and Mississippi to file in the Fifth Circuit. The FDA argued that only disappointed applicants, not retailers, could seek judicial review under the Tobacco Control Act. The Supreme Court disagreed, holding 7-2 that retailers who would sell the tobacco products if not for FDA's denial are adversely affected and can seek judicial review. Diamond Energy versus EPA involve fuel producers challenging EPA's approval of California regulations that require automakers to manufacture more electric vehicles and fewer gasoline-powered vehicles. The fuel producers argued these regulations reduce demand for gasoline and other liquid fuels, causing them monetary injury. The D.C. Circuit held they lacked standing because they couldn't show that invalidating the regulations would actually cause automakers to produce more gas-powered cars. The Supreme Court reversed 7-2, finding that fuel producers have standing because invalidating the regulations would likely lead to more gasoline sales through predictable market effects. Both cases present the Supreme Court with a fundamental question that keeps recurring in our regulatory state. When the government regulates one party, can other affected businesses challenge that regulation in federal court? This is particularly complex when the challengers aren't directly regulated but claim to suffer economic harm through market effects. In both cases, the government agencies and their allies argued that the challengers needed to produce extensive evidence about how third parties, retailers and Reynolds, automakers and Diamond Energy, would actually behave if the regulations were invalidated. The Supreme Court had to decide whether standing doctrine requires this kind of detailed proof, or whether more general economic reasoning suffices to establish that judicial relief would redress the claimed injuries. What makes these decisions so interesting is that they produced identical 7-2 splits, but with the majorities using completely different reasoning to get there. Justice Barrett's approach in Reynolds represents traditional judicial craftsmanship. She systematically dissects the statutory language, comparing the Tobacco Control Act's phrase, "any person adversely affected," with other provisions that limit standing to just the holder of application. Barrett builds her case like a lawyer arguing from precedent, citing cases across different statutes that have interpreted similar, adversely affected language broadly, from the APA to Title VII to the Fair Housing Act. She explicitly rejects what she calls the FDA's attempt to read the phrase "an applicant" into the provision, when Congress chose broader language. Her analysis is methodical and textual, focusing on what Congress wrote versus what it could have written if it wanted to limit standing more narrowly. Justice Kavanaugh's approach in Diamond Energy is strikingly different. He's much more willing to embrace what he calls familiar economic reasoning and reject demands for extensive empirical proof. Kavanaugh explicitly endorses EPA's own statement that common sense economic principles can be useful when evaluating standing, then applies that logic to conclude that regulations forcing automakers to make more electric vehicles will predictably harm fuel producers. But what's particularly notable is how Kavanaugh handles the government's counterarguments. When EPA and California argue that market forces have rendered their regulations ineffective, Kavanaugh essentially calls their bluff, writing, "If invalidating the regulations would change nothing in the market, why are EPA and California enforcing and defending the regulations?" He's comfortable making inferences about regulatory effectiveness based on the government's own litigation behavior rather than demanding economic studies. Where Barrett's Reynolds opinion reads like a traditional legal brief, carefully building from statutory text through precedent to conclusion, Kavanaugh's Diamond Energy opinion reads more like policy analysis, focusing on practical market realities and regulatory dynamics. Kavanaugh explicitly warns against courts requiring affidavits from regulated third parties, because that would make standing dependent on whether the plaintiff and third parties share litigation interests. Barrett, by contrast, stays focused on what Congress intended when it used specific statutory language, building her argument through careful textual comparison rather than policy concerns about courthouse access. The dissenting approaches reveal this same methodological split, but from the opposite perspective. In Reynolds, Justice Jackson focuses heavily on the statutory scheme itself, arguing that the majority ignores how the Tobacco Control Act is structured around manufacturer-FDA interactions with no role for retailers. She performs a detailed zone of interest analysis of the specific provision that respondents claim was violated, concluding that retailers simply aren't protected by that statutory framework. But in Diamond Energy, Justice Jackson takes a completely different approach, focusing on what she sees as inconsistent application of standing doctrine and arguing that the court demands much stricter proof from individual plaintiffs than from corporate ones. Her Diamond Energy dissent is less about statutory interpretation and more about judicial consistency and fairness. The court's decision not to cross-cite these cases becomes particularly significant when you see how different Barrett's and Kavanaugh's analytical approaches really are. Rather than creating a unified standing doctrine, the court appears to be developing separate methodological tracks: Barrett's careful statutory interpretation in Reynolds, and Kavanaugh's practical economic reasoning in Diamond Energy. The identical voting patterns tell us where the justices stand on access to federal courts, but the completely different reasoning shows they're willing to use whatever analytical tools work best for the specific legal context rather than forcing every standing question through the same doctrinal framework. All right. Those are additional insights I wanted to share with you about last week's 11 opinions. We're now in the final stretch. By my count, 11 unique cases remain. These aren't the administrative law tidying up cases we saw earlier. Some of these are the blockbusters, the constitutional powder kegs. The most explosive case awaiting decision is undoubtedly the Consolidated Trump vs. CASA immigration enforcement trilogy. Argued on May 15th, these cases pit the Trump administration's aggressive deportation policies against the persons and states who attempt to secure nationwide injunctions. The fact that the court expedited these applications signals the justices recognize the urgent constitutional crisis at hand. Close behind in constitutional significance is Free Speech Coalition versus Paxton, which tests whether Texas can restrict adults' access to sexual content online in the name of protecting minors. The Fifth Circuit's application of rational basis review, rather than strict scrutiny to a law-burdening adult speech, has created a circuit split that goes to the heart of First Amendment jurisprudence. This case could fundamentally reshape how courts balance child protection against adult speech rights in the digital age. The Voting Rights Crucible. Louisiana v. Calais and its companion Robinson v. Calais present the court with perhaps its most significant voting rights case since Allen v. Milligan. The three-judge court's finding that Louisiana's redistricting constitutes an unconstitutional racial gerrymander, even after the state created a second majority black district as courts demanded, creates a constitutional catch-22. If states can't comply with the Voting Rights Act without violating equal protection, the court may need to fundamentally recalibrate the relationship between these constitutional commands. The sleeper cases with major implications. Don't overlook Hewitt v. United States and its companion Duffy, which have been pending since January 13th arguments. While sentencing law might seem mundane, these cases affect thousands of federal prisoners and test whether the First Step Act's reforms apply retroactively. The circuit split here is acknowledged, and the court's delay suggests internal disagreement about how broadly to read criminal justice reform. Kennedy v. Braidwood Management deserves special attention given the court's unusual post-argument supplemental briefing order. The justices' demand for additional analysis of whether Congress properly vested HHS authority to appoint task force members, with specific reference to 19th century precedents Hartwell and Smith, suggests the court is considering a narrow appointments clause ruling rather than the broader non-delegation challenge. The fact that the court hasn't relisted the case for re-argument since receiving the May 5th supplemental briefs indicates the justices may be close to resolution. The religious liberty battleground. Mahmoud versus Taylor presents a perfect storm of contemporary culture war issues: religious exercise, parental rights, and LGBTQ plus curricula in elementary schools. The Fourth Circuit's narrow reading of Wisconsin versus Yoder, finding no religious burden because parents aren't forced to change their religious beliefs or conduct, conflicts with other circuits' more expansive interpretations. This case could significantly expand or contract the scope of free exercise protections in public education. Administrative state under siege. The Consolidated FCCV Consumers Research cases represent the court's latest opportunity to restrict federal agency power through the non-delegation doctrine. The challenge to the Universal Service Fund's structure, questioning both congressional delegation to the FCC and the FCC's subdelegation to a private administrator, could revolutionize how federal agencies operate if the court finds constitutional violations. Those are details from last week's opinions that I wanted to share. Let's turn our attention now to the Supreme Court's June 23rd order list, and specifically, the one case within this list that the court agreed to hear: Landor v. Louisiana Department of Corrections, case number 23-1197. The Supreme Court must answer whether prisoners can sue prison officials personally for damages when those officials violate their religious exercise rights. This case brings together two of Congress's most important religious liberty statutes: the Religious Freedom Restoration Act of 1993, RFRA, and the Religious Land Use and Institutionalized Persons Act of 2000, RLUIPA, and forces the court to confront a fundamental question. When the government violates your religious rights, should you have meaningful recourse, or should officials be able to act with impunity? Let me tell you Damon Landor's story because it captures everything that's at stake here. Damon Landor is a devout Rastafarian who had maintained his religious dreadlocks for nearly 2 decades in accordance with what's called the Nazirite vow, the same biblical oath taken by Samson. His locks sat almost to his knees. In 2020, Landor was incarcerated in Louisiana for 5 months. The first 2 facilities respected his religious beliefs and accommodated his dreadlocks, but with just 3 weeks left in his sentence, everything changed when he was transferred to Raymond Laborde Correctional Center. Here's where the story becomes truly egregious. Landor proactively informed the intake guard that he was a practicing Rastafarian. He provided documentation of his past religious accommodations, and, this is the kicker, he actually handed the guard a copy of the Fifth Circuit's decision in Ware v. Louisiana Department of Corrections, which held that Louisiana's policy of cutting Rastafarian hair violated RLUIPA. The guard's response? He threw the Fifth Circuit decision in the trash. The guard then summoned Warden Marcus Myers, who demanded that Landor produce documentation from his sentencing judge corroborating his religious beliefs. When Landor couldn't instantly provide that specific documentation but offered to contact his lawyer to obtain it, the warden mockingly replied, "Too late for that." What happened next can only be described as a deliberate assault on religious liberty. Prison guards escorted Landor to another room, forcibly handcuffed him to a chair, held him down, and shaved his head to the scalp. Let that sink in. These officials literally threw away a federal court decision protecting Landor's rights, then physically restrained him and destroyed what he considered sacred. The legal framework. To understand why this case matters, we need to examine the legal landscape. After Employment Division versus Smith in 1990 essentially gutted religious liberty protections, Congress responded with 2 landmark statutes. First came the Religious Freedom Restoration Act, RFRA, in 1993, which initially applied to all governments. But the Supreme Court struck down RFRA's application to state and local governments in City of Bourne versus Flores, finding it exceeded Congress's power under the 14th Amendment. So Congress went back to the drawing board and crafted RLUIPA, the Religious Land Use and Institutionalized Persons Act, in 2000. This time, Congress relied on its Spending Clause and Commerce Clause powers, making the law applicable to institutions that receive federal funding or affect interstate commerce. Both statutes use nearly identical language, both restore the compelling interest test, and both provide that a person may obtain appropriate relief against a government for violations. Here's the critical point. In Tanzine v. Tanvir in 2020, the Supreme Court unanimously held that RFRA's appropriate relief language permits individual capacity damages suits against federal officials. The court found the text clear and emphasized that damages are often the only form of meaningful relief for religious liberty violations. The Circuit Court ruling. When Landor sued the Louisiana officials for damages under RLUIPA, both the District Court and the Fifth Circuit dismissed his claims. The Fifth Circuit acknowledged that it emphatically condemned the treatment that Landor endured, but held that circuit precedent barred individual capacity damages under RLUIPA. The court's reasoning? Because RLUIPA was enacted under the spending clause. It operates like a contract, and only the grant recipient, the state, may be liable for its violation. The court distinguished Tanzan on the ground that RFRA and RLUIPA rely on different constitutional powers. This decision prompted sharp division when the case went to en banc review. Judge Clement, writing for 9 judges, concurred in denying rehearing, but urged that only the Supreme Court can answer whether damages are available under RLUIPA. She noted that threading the needle between Sotomayor and Tanzan is a task best reserved for the court that wrote those opinions. Judge Oldham, writing for 6 judges in dissent, argued that the panel's result cannot be squared with Tanzan because RFRA and RLUIPA use identical language and are routinely interpreted as sister statutes. Landor's petition makes several compelling arguments. First, the Tanzan precedent should control. The Supreme Court held that RFRA's identical appropriate relief language clearly permits individual capacity damages. Since RLUIPA uses the exact same phrase, the same interpretation must apply. As Judge Oldham noted, the operative provisions are in haec verba, in the same words. Second, RFRA and RLUIPA are sister statutes that the Supreme Court routinely interprets in harmony. Both attack the same wrong, substantial burdens on religious exercise, in the same way, using the same words. There's no principled basis for treating them differently regarding remedies. Third, Congress has constitutional authority under the spending clause to create individual liability. The Dole test is satisfied. This protects the general welfare, provides clear notice to states, relates to the federal interest in protecting religious exercise, and doesn't violate other constitutional provisions. Fourth, and perhaps most importantly, damages are often the only meaningful remedy. As Landor's case demonstrates, injunctive relief is useless for someone who's been released from prison or whose religious property has been destroyed. Without damages, RLUIPA becomes what Landor calls an empty promise. Louisiana's brief in opposition raises several arguments that deserve consideration. First, they emphasize there's no circuit split. Every court of appeals rejects individual capacity damages under RLUIPA. They argue this unanimous agreement suggests the issue isn't worthy of Supreme Court review. Second, they invoke spending clause limitations, arguing that such legislation operates like a contract and can only bind the actual recipient of federal funds, the state, not individual employees who aren't parties to the funding agreement. Third, they rely heavily on Sotomayor v. Texas, where the Supreme Court held that appropriate relief is open-ended and ambiguous and doesn't clearly permit damages against states. They argue the same ambiguous language can't simultaneously satisfy clear statement requirements for individual liability. Fourth, they raise practical concerns about prison staffing shortages and potential chaos in other spending clause legislation like Title IX, where courts have similarly rejected individual capacity claims. The United States weighs in. The Supreme Court requested the Solicitor General's views, and the United States filed a brief supporting Landor. This is significant. The federal government is urging the court to interpret RLUIPA to permit individual damages. The government's position is straightforward. Tanzan's interpretation of identical language in RFRA compels the same result for RLUIPA. The Solicitor General emphasizes that Sotomayor only addressed sovereign immunity concerns that don't apply to individual officials, and that Congress has clear constitutional authority under the spending clause to create such remedies. I'll be watching closely when this case is argued, likely sometime in the fall or winter of 2025. As oral arguments approach, I'll be sure to further discuss this case. That's it for today's episode. Thanks for listening to SCOTUS Oral Arguments and Opinions. If you found this analysis helpful, please subscribe and share. Talk you soon.